back to our series in the area of wills and estates. My name is Heather Her the Twin. Today, we're going to talk about what a power of attorney is. So while many people are familiar with what wills are for, powers of attorney may not be as well understood. So joining me here is our regular guest speaker on Litigation Help, Toronto lawyer Samuel Michaels. Hi, Sam.
Hi, Heather. Thanks for having me back. Really excited to get into it for today.
Okay, great. Okay, so Samuel, can you please explain to us what power of attorney, what does that mean?
Yeah, absolutely. So a power of attorney is basically a document that gives someone else control to make decisions on your behalf. So when we're talking about the estate planning overall umbrella, we have the will, which is drafted for after you pass away. In the time before you pass away, if the documents needed to govern your affairs before you pass on, that would be the power of attorney. So it's there in case you have a situation where you're mentally incapable or because of a sickness, you're unable to make decisions for yourself.
So can you, I hear that there are several types of power of attorneys. Could you maybe go through them and explain them for us?
Yeah, absolutely. So today we're going to focus on the estate planning context, which is basically your power of attorney for personal care and your power of attorney for property. There are all types of different power of attorneys that can be given for other purposes. So for example, a common one that I deal with in corporate is that a shareholder, let's say an investor who doesn't want to be really hands-on involved with the company, may sign a power of attorney in favor of another shareholder or director who will make the decisions on their behalf and essentially do the voting on their behalf and whatever else is needed. So there are power of attorneys that are just sort of specific purpose like that, right? They're just for one thing that needs to be done or one authority that needs to be granted. But in the estate planning context, it's a little different. The power of attorneys basically automatically kick in when you're incapacitated or unable to make decisions. And then they can govern all your affairs instead of being limited to a specific activity or action.
Can you maybe explain a little bit more about the difference between a general power of attorney and a continuing power of attorney?
Yeah, so the general power of attorney would be like the example I gave, right, for a business. So that's like a specific purpose power of attorney. It comes in, and if the person is incapacitated later, the power of attorney would actually stop. A continuing power of attorney is a power of attorney that's active as of the day of signature, but it's limited by certain conditions, which we'll actually see. So I'm going to share a template power of attorney on the screen, and we'll see those conditions that limit it to only come in when the person's incapacitated. So technically, a little weird to think about, but the power of attorney from the day of signing is actually active. It just can't be used to do anything until the incapacity of the individual is granting it. At that time, the rights actually kick in for somebody to take over authority of signing checks on the person's behalf, making medical decisions, whatever else is necessary for the individual.
Wow, so it's really good that you point that out because if a person just had the general power of attorney, sometimes they don't realize that it actually stops being valid once you become mentally incapacitated. So it's really important, I guess, yeah, that you get the right one done.
Yeah, the continuing power of attorney does continue until you pass away. So yeah, that's just it. Like you have to have the right documents in place, right, depending on what's needed.
Okay, so Sam, you said that you were going to take us on a template to maybe just do a little demo of filling out one of these forms.
All right, so I have a template here for the power of attorney for property and the power of attorney for personal care. So I thought it'd be interesting to just quickly go through it. All the names are switched out to fictitious names, but basically the content is as you would see it for a real POA that I would do. So I'll sort of go quickly through the sections. We don't need to read every word right now, but just to get a general idea of what is included in the power of attorney. So first, we're dealing with property. So this is the management of essentially your assets, your bank account, your car, your home, anything else that would need to be managed while you're in a state of incapacity. So the first section is going to be the appointments. Typically, what I like to do is have at least two attorneys, a named attorney and an alternate attorney. There's several ways you can set this up. You can do two primary attorneys and two secondary attorneys. You can do one primary and two alternates, two primary, one alternate. You can have three, right? One, and then if they're not available, a second, and if
Right.
they're not available, a third. So there's lots of options. I generally recommend have at least two. The reason is just that if something happens, right, to one of those attorneys, to have another person who's there and available. It is possible to re-sign a power of attorney to enter into a new one after, but because these are supposed to deal with emergency situations,
Mhm.
I wouldn't count on having an opportunity to redraft it
Right.
anytime something happens, right? So I'd have some fallbacks in there if it just so happens that, for example, due to a change in your situation that you can't have the same attorney anymore, you can make the change. It's not a problem to switch them out. But generally, if you can try to have at least two, it's a good idea. You can have them again together. I have a slight preference. I think this is just personal, but I slightly prefer having one attorney. I think there's a bit more room for dispute. So, for example, if a decision has to be made around the property, if there are two attorneys with competing viewpoints, that could lead to problems for managing the assets. So I slightly favor having one attorney named who's a trusted individual that will make appropriate decisions on your behalf. That being said, I totally understand for many people, especially people with two children, it's really, I want to have both children, right, acting together, and that's totally fine as well. And then you see that, the attorney has the authority, right, to take any actions on the person's behalf, even to start litigation on behalf of the person. And here's sort of the key clause that it's a continuing power of attorney. So that means that the authorization is as of the signature date, and it may be exercised during any incapacity. So even though it comes into effect today, let's say, the actual use of the power of attorney only comes in when there is an incapacity for the person granting it. And then when we go through for the rest, is basically saying, the person confirming that they understand who the power of attorney is and that the power of attorney is going to be responsible for their property. And then some conditions and restrictions on the power of attorney itself. And this section, you can really get into quite a bit in terms of the control of property, restrictions on property and how things are managed, conditions for how the power of attorney should act, and giving them delegation authority, right, to sign lawyers or accountants, whoever else is needed in order to take the steps that they need to manage the affairs of the individual. Within this section, though you can put more restrictions, I will usually advise against it. And again, it just comes down to there's so many situations that can happen in the future. You can't possibly get every possibility into a power of attorney. It would be, a 10,000 page document, right? What happens if my house floods? What happens if there's a foundation issue in my house? What happens if,
Right.
I could go on and on just on a house, and that's only one piece of property, right? Person has bank accounts and cars and all these things. So
Right.
you can't really put everything in. And what can happen is if you just speak to a few things, you might miss some other factor or circumstance. So, for example, if you say, in the case of a flood, sell my house. Well, that might sound good, but what if it's a very minor flood, right? What if it's a flood that can be repaired for $1,000 repair? Well, now the POA says you have to sell the house. So are the power of attorneys now locked into this sale just based on, this tiny minor event? That's just one hypothetical, but it's things like that that can happen that I'll usually recommend. If you trust your power of attorney, if you trust that they'll make good decisions on your behalf, that should be enough. Leave the authority with them. Don't restrict their activities because they're not going to do something against your interests. And typically, if you're appointing a child, a parent, a close friend, a close family member, you can have that confidence that, you might not agree 100% with every single decision made, but that they'll be making decisions in your best interest, and trying to restrict that may actually just lead to more trouble than it's worth. It might just lead to more problems.
Mhm.
So then we have a few sort of general clauses. There is a compensation clause to allow the attorney to receive compensation. The idea here is that being a power of attorney is not a paid position, right? It's not earning big income from it, but there
Mhm.
are a lot of obligations. So often I'll recommend to people to put in a compensation section just in case something comes up where the attorney needs to use
Mm.
hours and hours of their time. For example, if the individual granting the power of attorney is involved in litigation
Mhm.
and that litigation has to be taken over by the POA,
Mhm.
that person could actually end up spending dozens of hours, hundreds of hours, right, dealing with
Mhm.
document collection and attending the hearings and all that stuff. So I think it's a good idea to have that compensation clause. Again, it's not going to be a profitable experience for them, but at least to reimburse, right, some of the time and cost that they're putting in.
Mhm.
And then we have the witness signature area. And this is very important for a power of attorney, um, because without the proper witness signature format, there may be validity and enforceability issues with these documents.
Mm.
So when you're signing a power of attorney, the power of attorney needs to be signed at the same time and in the presence of two witnesses. And this is the same as for the will. It can't be I sign with one witness and then the next day bring it over to the other witness. Everyone has to be there at the same time, same event, one sequence. Testator signs, the person granting signs, witness one signs, witness two signs, all in one continuous action between the parties.
Mhm.
So far, as of today's day, we're January 2022. I think on all our videos, I give a date because we're
Mhm.
speaking about these COVID issues. So far, we have remote signing. And the reason I give a date as always is because these rules are subject to change. They only came in a year, 2 years ago. And, it's possible they may not last forever. So
Right.
a remote signing where everyone's on a video call like me and you are right now,
Yep.
and essentially sending the document around electronically for signatures is possible. But again, these rules are all subject to change. So if at all an option for the parties, I would recommend to just do it in person, right? Get together and at least for the three, the witnesses and the grantor, to get together and complete the signing. It's also a matter, I do wonder, even if these rules stay on the books,
Mhm.
when we're talking like 20, 30 years down the road, um, I do again slightly favor keeping to a more standard and traditional format.
Mm.
Documents could be looked at, way past COVID is an ancient memory, hopefully, fingers crossed, right, by
Right.
that time.
Yes.
But trying to bring in these rules and saying, oh, way back in 2021, we had this exception, that could lead to some complication. Not necessarily. This is a bit of bit of guesswork on my behalf, but I think if it is possible, if it's safe and healthy for all the individuals, and you can just do it in the standard format that's accepted 100% of the time, I would have everyone get together.
Right.
The last sort of piece in the affidavit for property, and we'll go over the POA for personal care, but format wise, very similar.
Mhm.
Um, they're generally affidavits of execution. So the affidavit is basically like a piece of evidence. So if ever a court or a bank or a financial advisor, anyone else wants to know, was this in fact witnessed and signed? I'm seeing the witnesses here, but were they actually there on the same day? Was this actually done in a valid way? The affidavit is the piece of evidence you bring forward to say, yes, it was. And the affidavit just confirms, I was present, I saw this being signed, I saw the other witness there. I'm not the attorney or a spouse, right? There's some things that would void you from being able to act as a witness. So you have to say, I'm not in one of those roles. And then you sign the affidavit, having it commissioned by a lawyer. And basically, this affidavit is just going to serve as essentially the evidence piece, right? So instead of, if the bank reaches out, they say, hey, we want confirmation that this was validly signed. Instead of calling them and saying, hey, I was the witness, I signed it, you would submit the affidavit, right? So it serves that purpose of providing that evidence. So for any affidavit that you're signing, not just the affidavit of execution, the document actually also needs to be commissioned. And a commissioned document is basically a document that's signed in the presence of a lawyer where the lawyer is essentially giving you an opportunity to swear a statement saying that what you're swearing to is true and accurate. So in this case, that you were in fact there for the signing, you in fact saw the grantor signing their name, you in fact were there with the other witness. There can be a little confusion between commissioning and notarizing a document. In Ontario, we also have a notary public. Notary publics can be a lawyer, or it can be anyone who applies and receives the certificate to act as a notary public.
Mhm.
And basically, when you have a document notarized, you're essentially verifying that the notarized copy is a true copy of the original. So it's a little different in the commissioning is you're swearing to the truth of something. Notary is essentially the notary public saying between these two documents, they're the same. They have the exact same content and format and all that. And I think that will pretty much take us through what's needed. So you have an affidavit for both of your witnesses. Those get attached. Essentially, you can just paperclip them to the end of the power of attorney. And then the document's printed and stored. Usually I recommend for the grantor to store it somewhere where the power of attorneys know where it is and have ready access to it.